Hi, I'm Tom Mihawk. This is my personal finance course. This is segment 3 of the chapter on estate planning. We just finished talking about trusts and how useful they can be in estate planning. Now we're going to talk about revocable trust. Two types, revocable and irrevocable. The terms of a revocable trust may be changed during your life. The assets really remain your assets. They may help avoid probate, however, when the assets are registered with the trust and when you pass, become part of the trust, become owned by the trust or held by the trust. That helps maintain privacy. As we spoke of in the first segment about good estate planning and poor estate planning, many of the good estate planners used trusts like revocable trusts and pour over wills, which used trusts to gather assets, to keep privacy and keep assets out of probate. Probate, by the way, is a legal process of vetting the will. And in many cases, probate is not necessary for smaller estates when there's joint ownership of assets, when there's use of trusts. But if the will has to be decided by a court, if assets pass outside of these techniques, the will may have to be probated, and that means everyone learns about the contents of the will and about aspects of your life you may not want them to learn about. A revocable trust does not offer creditor protection. If you're sued, the assets that are registered to the revocable trust can be attached. I remember as advisory clients, people in the real estate business use this kind of planning often. Sometimes you'll find real estate people have their homes registered in their spouse's name because they're in highly leveraged businesses that sometimes have bankruptcy or creditor issues. And so revocable trusts do not offer creditor protection from lawsuits or creditors' claims. Assets are subject to federal and state estate taxes upon death. They're generally not used to avoid taxes, but they are used to avoid probate, as I said, and can be used to distribute assets over time in the future after you've passed. They're very popular planning tools. By comparison, irrevocable trusts may not be changed during your life, theoretically. They're designed so that when you contribute assets to an irrevocable trust, it is no longer your asset. It is now an asset of the trust. And for that reason, the IRS can't tax you for the benefit of those assets, but they tax the trust. Assets contributed to irrevocable trusts are no longer yours. They become trust property, no longer owned by the donor, you in this case. It's an important planning tool to help reduce estate taxes. It may help you avoid probate. It does offer creditor protection from lawsuits and creditor claims. A very popular planning tool. Irrevocable trusts often own life insurance to help fund estate tax liabilities. What happens is the trust is put together first. The insurance is contributed to the trust because you don't want to wrap insurance inside of a trust. There is a look back that the IRS does, and if someone passes, the trust is considered as if it never existed. So you build a trust first, contribute the insurance later. You make sure that the trust has enough assets to pay the premiums, further evidencing that it's not your asset but the trust's asset, and there are techniques to fund the trust to do this. Pay the premiums with a trust check from a trust account, and when you pass, the death benefit proceeds pay to the trust, and then the trust distributes according to your wishes as you've set up the irrevocable trust while you were living. So irrevocable trusts are very popular planning tools. Durable power of attorney is another very important legal document you need as part of your estate plan. Remember the three most important, right? Wills, durable power of attorney, and in the next slide we're going to talk about healthcare directive. A durable power of attorney is a legal document that authorizes someone to act on your behalf when you're incapable of doing it. You could have a chronic illness when you're older, for example, Parkinson's disease, dementia. It could be you've just suffered an auto accident and you can't make decisions for yourself. It can be financial, regarding, say, paying bills or making financial decisions, or health related, authorizing surgery, for example. You've had a serious auto accident, you go into surgery, and the physician says, okay, who's signing on behalf of Mr. Smith who needs this surgery? Who's there? Who has the power of attorney? Let me see it. durable power of attorney, or power of attorney, I guess, in that case. The durable would do too. Healthcare Directive is a legal document that states your wishes regarding delivery of healthcare or medical intervention, or not delivery of those items, when you are unable to do so. This document came out of the case of Terry Schiavo, where she was on in a coma, I believe. But the point is she was living on machinery, medical equipment, and her husband had a different view than her parents regarding whether the equipment should stay affixed to her. So her husband believed that she would not want to continue to live if she was in a vegetative state and without and would pass. And if it were not for the equipment, she would not be living. Her parents, due to their religious beliefs and their view of their daughter's religious beliefs, felt that she would want to have that medical equipment stay protecting her life. This lasted 10 years. It went through multiple courts up to the U.S. Supreme Court. It ended finally in 2005 when Terry Schiavo passed. So this was a huge bad experience for the families, and it's influenced estate planning ever since. So this is called a healthcare directive. Contents, construction, and vocabulary of these documents vary state by state. It's also called an advance directive. Sometimes people call these living wills. But the point is a healthcare directive is a generic term that everyone uses, any state. People know what that is. Again, three most important things: will, durable power of attorney, healthcare directive. Prenuptial agreements can sometimes be awkward. They're designed to settle financial matters in a marriage before a dissolution of the marriage before death. They're beneficial when one person entering the marriage has substantially more assets than the other. Maybe has children from previous marriages, debt from the other spouse that they wish to remain free of in the case of a divorce. It can be awkward, but it's smart financial planning if the circumstances indicated. If you enter a marriage and your assets are far greater than your soon-to-be spouse, or the reverse is true, you enter a marriage with much less assets than your soon-to-be spouse, a prenuptial agreement may be warranted. I saw a situation once where a doctor was on a second marriage and his wife literally vested. They had a 10-year window, and with each year she vested into more assets in the marriage, such that after the 10th year she would receive a split of the assets if they later divorced on an equivalent basis to the husband. The husband entered the marriage with much more assets than the wife did. If they were to divorce in the first year, she would receive very much less. Community property states are those states from Louisiana, Texas on west, up the west coast, roughly, and then maybe Idaho and Wisconsin. And they're states where, in the case of a dissolution of the marriage, the husband and wife split equally the assets accumulated together during the marriage. They're split equally upon divorce. They're called community property states. Now, other states, of course, if you're divorced and you're domiciled in Florida or Maryland or New York or Illinois, of course you're going to argue that you deserve a fair share of the marital assets. I'm sure in plenty of the cases you see on TV or read about, people argue for more. I don't know. But the point is that these states have been set up automatically so that marital assets are split 50-50 upon a divorce. So, an estate inventory and action list. This is key, and this comes from literally from, with some additions farther down, but from slide 3. The cash and personal effects you own, securities, real estate, trusts. I'll let you read the rest of them, but the point is, know what you own, and then add what you owe. Mortgages, lines of credit, credit cards. Know what you own and know what you owe. If you need to take photographs, do that. Make a list. And it's important to put together a post-death action list, a post-death action list. Before my dad passed, he gave me a list of items with contact names, phone numbers, of investments and insurance and pensions and other benefits that he had earned that he wanted my mom to gain the benefit from, or she deserved the benefit from. And so I had this list, and I remember, calling these people. I mean, it was challenging to do after my dad had passed. And it's those things after someone passes are always hard because you're grieving. But my dad gave me a great list. It was clear and easy to use, and I think my mom was therefore, well cared for given how they planned. Contact names, information for investments, advisors, insurance carriers, pensions, retirement plans, phone numbers, all those kinds of things are really important. Property ownership, how you title property is vital, and it's a very important element in estate planning. There are only three ways that property may be owned: individually, solely, or without a beneficiary designation; joint, it's typical for marriages. When one owner dies, ownership automatically passes to the other owner. It offers the potential for avoiding probate. I've seen situations where, father passes, mom lists children with her as owners on accounts at banks, for example. And when mom passes, those assets transfer directly to children in accordance with the plan of the father and the mother prior to their deaths. And so that way does work. Now, if the amount is $50 million, that's a problem. If the amount is 5,000, that's different. So you have to look at those gift transfer items issues too. Payable or transfer on death. These are accounts and deeds and trust for accounts, retirement accounts. Owner has full control during their life, and after death, the property passes outside of probate to the beneficiaries designated by the owner. In general, beneficiaries need to produce a death certificate in order to verify ownership for joint assets and payable or transferable on death. Meaning that in the example I gave before of the dad has passed, mom puts children on the accounts. When mom passes and the children want to distribute those assets amongst themselves in accordance with the parents' wishes, they would show up at the bank or the mutual fund and they would evidence a death certificate. And the instructions would be for the financial institution to distribute according to the ownership at that time. Life insurance is commonly used in estate planning. It can replace net worth otherwise used to pay estate taxes. It's not done specifically that way, but conceptually that's what's happening. It's used to equalize the amount received by heirs. For example, when private business owners, when 2 children are in the private business and 2 are not, and maybe the company's sold and assets go to the children in the business, well, insurance can be used to equalize for the children who weren't in the business. I've seen, by the way, this situation happen and insurance wasn't used and it was a nightmare. And so insurance can be used to equalize estates among children relatively inexpensively. And for special needs children, insurance can be used to provide for special needs children for their needs after the parents have passed. For charitable bequests, charities are very happy to receive ownership of life insurance. I work with a man who went to Harvard. He had 2 daughters that went to the University of Virginia. He carved out part of, I believe it was, if I remember correctly, a $5 million face amount in his life insurance portfolio, carved out part of it and gave it to the University of Virginia as a donation. Now, he was at that point on a committee to raise money for the University of Virginia. I remember asking him, why don't you give to Harvard? And he said, Harvard has plenty of donors. Virginia needs more money and they need more donors. University of Virginia was happy to receive this life insurance. They didn't say, no, we don't want it. It's not cash, not stock. No life insurance. No, they said we were very happy. And he transferred ownership and they became beneficiary of the death benefit. They would receive that when this man passes. So, summary of estate planning. When you need these 3 documents, as I said: will, durable power of attorney, healthcare directive. When you have dependents, assets, liabilities, or a spouse, have a will, durable power of attorney, and healthcare directive. Copies stored in safe places, maybe multiple copies. Don't delay. You can always change them, for example, with a codicil. Plan for federal and state estate and inheritance taxes. Not many people qualify for them, but those that do, they are onerous taxes. You quickly get to the highest rate, 40%, quickly. And these things change. I mean, it had been higher than that during my financial advisory career, and the exemptions were much lower, and it could change in the future. Know your state and know its taxes. Review your will regularly, and along with it, your power of attorney and healthcare directive. I sat in with a client who was a senior executive at a family-owned apparel company, and he was maybe fifth generation, something like that, and had been remarried now to a second wife for 10 years, who had children herself from a previous marriage. And he was changing his will, amending it to include these children that he now considered his own. He'd been married to his second wife for 10 years. These children were not his, but he considered them his own. He was including them in his will. It wasn't long after that he died running on a treadmill at his company's office. And he was an athletic man. He played baseball in college. And so his updating his will included and made clearer his intentions for the children of his second wife's first marriage that he now considered his own children. And that made their lives far better when the bad thing happened that he passed at a young age. Use trusts to your advantage. Don't consider the language that they're used in movies and you read about. Trusts are very effective planning tools. Use them to your advantage. Keep records of your property for an estate inventory. Have a post-death action list where you list insurance companies, investments, pensions, 401k plans, contact names, phone numbers that survivors can use to gain the benefits that you've put together. Title property according to your planning goals. Get advice if you need it. Titling property is key and can help you keep assets out of probate. Use life insurance to your advantage. Find experienced life insurance advisors, those with depth of finance knowledge, depth of personal finance, who have your interests in mind and will help you make decisions that help implement your planning and benefit your family. Get good advice if necessary. This has been the chapter on estate planning. I hope you've enjoyed it. This is my course in personal finance. I'm Tom Mihawk. You can find me at tommihawk.com. You can find these slides that I'm dictating and doing the audio over on YouTube at my YouTube channel. I'm Tom Mihawk. Thanks very much. Please come back for the next chapter.